All right. Hello, everybody. Welcome to the inaugural Green Tiger Markets Learning Academy session. Over the last 3 years at Green Tiger, we've had a large number of conversations with our clients about forward markets and launching the Philippines electricity contracts for different products on our platform. And over time, similar questions have raised their heads relatively frequently in these meetings that we've had with our clients. And so after discussing it amongst ourselves, we've identified certain areas where we feel that the team at Green Tiger Markets is pretty well placed to provide training and education to the market. So born from this is the Green Tiger Markets Learning Academy. And this is the first of what I hope, at least, will be a number of sessions in the coming months and years, maybe. So today we're going to start with the legal foundation blocks for trading on the Green Tiger Marketplace. Let me just let some people in from the waiting room. And that is the documentation architecture. Let me share here as well. All right, just 1 second. I need to make sure I can still see who's trying to join. Okay, very good. All right, so as I said, we are starting with the legal foundation blocks for trading on the Green Tiger marketplace, or in fact, really in any OTC derivative transaction. This session is going to be an introduction to ISDA documentation, and I'm delighted to be joined by attorney Rafael Morales, who is the managing partner of Morales and Justiniano. Among many of his accolades and achievements, I would describe them all to you, but unfortunately, we only have an hour for today's session, and it will take way too long to go through them. But what I will say is that Attorney Morales is the leading securities and derivatives lawyer in the Philippines. That's not just my opinion. Attorney Morales has acted as Philippines counsel to ISDA itself for well over a decade and is relied upon by all international participants in the OTC derivatives market for his guidance and opinion on derivatives as they relate to the Philippines. As I said, I could read out all of his awards from the industry press, but we only have an hour, so I'm not going to do that. But what I would say is that Attorney Morales is also the author of the Securities and Regulation Code annotated textbook, which is really the guide for understanding the SRC in all its glorious detail. It's a delight to welcome him here today. Thanks very much for joining us, Attorney Morales. For my part, I have met most of the people who are on this call either in person or via Zoom at some point or another. But for those of you who I haven't met before, my background is that I am a derivatives lawyer. I'm the head of Asia Pacific for Green Tiger Markets, but my background is as a derivatives lawyer. I worked for the two firms that have been international counsel to ISDA over the last 20 years. That's Linklaters and Allen & Overy. And then I was at Goldman Sachs for 10 years as senior counsel to the Asia Pacific global markets business, and that included the Philippines as part of my role. In these roles, I've been fortunate enough to provide training and education to market participants on the ISDA architecture pretty frequently over the last 13 to 15 years that I've spent in the region. So I hope that you'll feel comfortable that you're in pretty safe hands today with Attorney Morales and myself going through this with you. There will, of course, be time for questions at the end. Probably not a lot, but let's see what we can do. But if you have any during the course of the session, please feel free to either interrupt me or to pose a question using the chat function, and we'll seek to address it as we talk. And as I said, we're going to record this session. It's being recorded right now. And so it will be available on the GTM website in due course as well. So if any of your colleagues aren't able to attend or haven't been able to make it here, just let them know that that will be coming in the future. So let's start. Our topics for today are set out here. We're going to start with an overview of the ISDA framework. What is ISDA? What are the main documents published by ISDA that will factor into trading on the Green Tiger marketplace, and how they operate and connect together. Then we're going to go through the key provisions of the ISDA Master itself and the schedule to the ISDA Master. That will be the real meat of the session today. We'll then discuss trade confirmations before going into a couple of elements of Philippines law that we thought would be good to discuss in this forum, as they've been among the questions that have risen their heads most frequently in our meetings with clients. Now, I want to impress upon you that today is an introduction to ISDA documentation, and the emphasis is on introduction. We don't plan to get into the absolute nitty-gritty today. We only have an hour, and no prior experience is necessary for today's session. Now, we aim to delve into more detailed areas in future as part of the Green Tiger Markets Learning Academy, but for today, this is an introduction. So, for example, in the future, we'll have a separate session on credit support documentation, as there's not really going to be time for it today. Today's session, I'll reiterate again, is intended to be introductory. So let's begin. So what is ISDA? Well, ISDA, as you may well know, is the International Swaps and Derivatives Association, and it's a global trade association that was formed in 1985 to represent OTC derivatives users. You can find a list of all the members of ISDA on its website, and if you were to look at that, you'll see it includes all sorts of different market participants: banks, insurers, asset managers, commodities firms, corporates, law firms, and others. So it's a wide-ranging group. ISDA's objective is to foster safe and efficient markets, and its main role is to develop standardized documentation which is used to document derivatives. This standardized documentation enables parties to focus on the commercial points rather than having to rehash the same concepts and language each time they enter into a transaction. So if everyone is using more or less identical documentation, then that allows parties to be able to negotiate the individual commercial elements that really matter to them, rather than getting bogged down in the minutiae of negotiating each contract from scratch. Standardized documentation aids the development of markets, which is one of the reasons why we use the ISDA Master Framework as the contractual foundation for trading on the GTM marketplace. And in addition to this, ISDA commissions certain legal opinions, which it publishes on its website for the benefit of its members. The Philippines opinions are, as I mentioned earlier, written by Attorney Morales, who is joining us today. So I'm going to move on to speak about the documentation that ISDA produces and how it all kind of meshes together. The main documentation is the ISDA Master Agreement. There's a 1992 Master Agreement and a 2002 Master Agreement, which updated the 92. We're not really going to refer to the 1992 much in this discussion because although there are still a lot of counterparties that continue to use the 1992 as the basis for their trading, the market as a whole has really moved generally towards the 2002. And all new negotiations of ISDA schedules are likely to use the 2002 as a starting point. The 2002 documentation is also the version of the ISDA Master that we use for trading on the GTM marketplace. So this slide here shows some of the key different components of the derivatives contract. And as you can see, there are quite a few. And because this is an introductory session, I've deliberately left out some of the elements that fit into the global derivatives markets because they aren't really that relevant for trading on the GTM marketplace, and we would get too bogged down in the detail. So the ISDA documentation architecture is flexible, and it provides the documentation of different types of derivatives. And it leads readers through some of the example types of transactions that you can enter into using it as documentation. So what are the component parts of this architecture? Well, as I mentioned, at the heart of it, we have the ISDA Master Agreement itself. And in particular, that's the pre-printed form of the master. You don't touch the pre-printed form. That's the first 35 pages or so of the agreement. That's available on the ISDA website, and that doesn't change. Now, what we have as an appendix to it is a schedule. That's still the ISDA schedule, and that contains provisions that are specific to the counterparty's overall relationship. So that's how they're going to trade on an ongoing basis, but it doesn't include transaction-specific terms. The transaction-specific terms are found in the confirmation, just below. And then in addition to that, we also have credit support documentation, which is for providing collateral to or from your counterparty. Now, as I mentioned, we'll touch upon credit support documentation a little bit later, but principally, we're going to have that as part of a separate session as part of the Learning Academy in the near future, as we see the marketplace develop. Now, as I mentioned, you have transaction confirmations that document the trades themselves, and these are entered into underneath the relevant ISDA Master Agreement, and they relate to the specifics of the individual transactions. So they contain the economic terms of the transaction that the two parties have entered into, and they sit underneath. Typically, there's one confirm for each transaction, and the confirmation will incorporate the relevant ISDA documentation and also its definitional booklet. What I mean by that is a huge number of terms are found in basically dictionaries for the individual asset class. So there are many different types of definitions booklets published by ISDA, but the main ones to be concerned with when trading on green tiger markets is the 2005 commodity definitions, which is incorporated automatically into all the transactions on the GTM marketplace. So just to give you a slightly broader context than just GTM, though, there are booklets for credit derivatives, equity derivatives, FX derivatives, and interest rate derivatives. So really, you've got a different definitional booklet or a different dictionary for each individual asset class. And what this means is that when you're looking at the documentation for a particular transaction, you might need to look across multiple areas: the master, the schedule, the confirm, and the definitions booklets, and maybe even your CSA, your credit support annex, to find out how it all fits together. And all of that standard form documentation is available on the website, but it does feel then like it can get a bit complicated, right? So we're going to get into why it's a bit more simple than that when you're trading on GTM, and what we've done to try and remove that complexity. And what I would say is, don't worry too much about all those other definitions booklets I just mentioned, because principally, if you're trading on green tiger markets, you're going to be looking at the 2005 commodity definitions. You don't need to look at the FX or the rates ones particularly, unless you're really interested. Okay, so with all those different documentation, all those different documents, the master, the schedule, the confirm, etc., what happens when, because you have so many different parts, what happens when you need to work out, well, if there's a conflict or contradiction between one part of it and another, which one is intended to supersede? So this slide shows that is the hierarchy. And I'm going to start at the bottom of the hierarchy. So you'll see that we have the pre-printed form of the ISDA Master Agreement at the bottom. And if you think about it, it makes sense for the pre-printed form to be right at the bottom, because that can't be touched. And generally, when we talk about contracts, the intentions of the parties are what takes precedence. So if you have a base document that can't be touched, then it makes sense for that to sit at the bottom of the hierarchy. Above that, we have the schedule to the ISDA Master, which is the points that have been negotiated between the two parties at a relationship level when they intend to start trading on an ongoing basis with each other. So, of course, because that's negotiated between the parties, that needs to sit above and take precedence over the master agreement itself. So that concept of superseding also informs the hierarchy of the collateral documents too. There are pre-printed forms of the ISDA Credit Support Annex, and again, that is capable of being amended by the parties depending on what they want to be the case for their specific agreements. And that negotiated part is called paragraph 11, which again, in turn, supersedes the pre-printed form. Then right at the top of the hierarchy, you have a confirmation, which is the trade terms. And as I've shown in the pyramid here, the confirmation prevails over all other documentation. And so to the extent that there's inconsistency between the confirmation and any of the other documentation in the ISDA architecture, the confirmation is going to take precedence for the purposes of the transaction that you're looking at. And so you might, as I say, be thinking, well, that's going to make it quite difficult for me to sift through all these different parts. and work out what the terms of the trade that we have with our counterparty is. And to be fair, that is potentially true. If you're trading particularly non-vanilla derivative transactions, it can be extremely complicated to go through all the definitions and work through what the terms of the trade are. But the good news is that the way that we prepared and documented the products on the Green Tiger Markets marketplace means that the terms of each transaction are more or less identical to each other, except for the specific commercial points that are negotiated bilaterally. That's either via the central limit order book or via our voice broker service. These terms are price, for example, the price per megawatt hour. Products, so for example, lose on round the clock for January of next year is the product. And then quantity in megawatt hours. So once you get to grips with the terms of one transaction and how it all fits together, all those different documents that we've just described, and then the confirm sitting on the top, you will actually then understand all the other transactions that are entered into on the marketplace, because you'll be able to see that it's the individual terms that are bilaterally negotiated that change, but actually the foundation, the legal framework that sits underneath it and makes sure that everything works, that is the same each time. That's the benefit of standardization, and that leads to liquidity, which of course is what we all want when we're trading, because it enables the best prices to be obtained. Okay, so that is the ISDA Master, the ISDA architecture. So I think we're ready to move forward to the next section, which is on the Master Agreement itself and what that says. Take a quick sip of water. While I pause for a sec, are there any questions that you have at this stage? As I said, you can feel free to put those in the chat function if you don't want to speak up. But otherwise, I'm happy to keep going. Okay, let's keep going. So in this section, we're going to cover the single agreement concept, which I'll explain in more detail in a sec. And that's one of the building blocks of the ISDA Master. Then we'll be looking at the main provisions of the ISDA Master Agreement itself. And then we're going to look at some of the points to think about when negotiating a schedule, should you decide to put in place an ISDA Master with your trading counterparties. So let's start off with the single agreement concept. The basic architectural structure of the ISDA Master Agreement is that you've got this master sitting right in the middle of the documentation. And the Master Agreement, as I said, comprises the standard pre-printed form that I've just mentioned. And we have the schedule that's been negotiated between the two different counterparties that are trading with each other. As I said, the form of the schedule is in the back of the ISDA Master itself. And that form invites the parties to make certain elections, and then parties can make specific changes that they want to as well. So these two documents, the master and the schedule, are sitting in the center of this arrangement. Then when people enter into transactions, each transaction is documented by a confirmation. Now, confirmation is pretty widely defined as any evidence of a transaction that's entered into, which is to be governed by the ISDA Master Agreement. Now, on Green Tiger Markets, the trade confirmation is what you receive immediately by email after you've entered into a transaction on the marketplace, whether that's via the central limit order book or the voice broker service. That confirmation expressly states that it forms part of the ISDA Master Agreement that's been entered into. And if one hasn't been entered into, then there is a deemed ISDA Master Agreement that is deemed to exist between the parties pursuant to the terms of the Green Tiger Markets rulebook. Now, the idea behind this is that, firstly, you want all the provisions of the ISDA to be incorporated into these transactions that you've entered into. The ISDA is intended to cover the whole relationship. So everything sits under that umbrella of the ISDA Master Agreement. But the second thing that's important is that by having all of the transactions form part of a single agreement, one agreement, that supports the idea that in the event of insolvency, you can't have an insolvency official cherry picking the transactions that they want to enforce and ignoring the transactions that they don't want to enforce. They can't just take all the ones where the entity is owed money and ignore all the transactions where the company is the debtor. Everything forms a single agreement, and so that produces a single sum or they've got to enforce the entire agreement altogether or not at all. And so that produces a single sum payable by one party to the other across all of the transactions that are entered into between the two parties. So, as I said, that's a critical point for how the ISDA architecture operates. So let's walk through some of the main provisions of the ISDA agreements that apply on an ongoing basis. And what I mean by that is that these provisions are the key ones in circumstances where you don't have a default or some other issue to deal with that might lead you to want to terminate the relationship. So I mentioned that this is a single agreement concept, and the fact that it is a single agreement is set out in section 1 of the ISDA Master. And then following on from that, the section 2 is what's called payment netting provision. And so payment netting is, you'll hear two types of netting during the course of this session. I want to distinguish between the two right away. So payment netting, which we're going to talk about in a second right now, is where under one or more transactions, you look at the gross payments that are payable between the two parties, and you decide to have a single sum payable on that day from one party to the other, just for operational efficiency. The other form of netting is closeout netting, and that's an entirely different concept that we're going to get into later. Okay, so there's payment netting, which is basically things are going fine and it's operationally efficient. And there's closeout netting, which is things have gone badly, and this is how we resolve all the outstanding transactions between us. So let's start with payment netting, and we'll get to closeout netting a bit later on in the session. So as I said, payment netting is dealing with the netting of payments which become due between the parties on an ongoing basis for the transaction, while they're live. Now, as I said, the main reason for having payment netting is operational. If there are two payments due under a transaction, one from each party in the same currency on the same day, then it doesn't really make sense for both parties to be making payments to each other in that currency. It would be much more convenient for the party that on a net basis owes more to pay the difference between the two amounts to, on a net basis, the party that owes less. We can see just from this really simple slide that party B owes 1,000 pesos to party A, but party A owes 250 pesos to party B. And so as a result, due to payment netting, party B pays 750 pesos on a net basis to party A. Super simple. It reduces the risk of mistakes and it makes it more operationally convenient. Now, this, of course, only works if payments are due in the same currency, which under the Green Tiger Markets platform for Philippines electricity, they all are. Now, obviously, they're in different currencies, US dollars and pesos, for example, then those payments can't be done on a net basis. But if it's the same currency, then it's all fine. Now, there's an operational efficiency to this, but there's also a credit risk advantage to payment netting in the sense that there's only one party making a payment. If there are two parties making payments, there's a risk that if one party makes a payment to the other, and then before that other party can make its own payment, it goes bust, then that, the performing party has sent money in one direction that is then kind of lost to the unsecured pool of creditors. So it has a credit risk advantage too. Now this slide is one transaction, but on the GTM marketplace, we use what's called multiple transaction payment netting. Now, what this means is that we take all of the gross sums under all of the transactions between parties in a given month, and then work out the net payment due from one party to the other across all of those transactions. So what happens is that after the prices have been published by IMOP, we work out what the settlements amounts are for all the transactions. And then market participants will receive a settlement statement from Green Tiger at the end of the month, telling them the individual net payments that are due from them to each of the other market participants that they have faced. So in this slide, we see that kind of worked out using simple numbers. But basically, across these three transactions, we see that party B owes party A 2,100 pesos. And across these, the same three different transactions, party A owes party B 1,200 pesos. And so on a net basis across these different transactions, party B owes to party A 900 pesos. And that's the single payment that's made. We don't have to make any of these other payments at all. We just make one payment from party B to party A. That's multiple transaction payment netting. Okay, let's go back to the main provisions. So the next clause is tax provisions. Now, I'm not going to go into any detail about this. You'll be probably happy to know today, as that's beyond the scope of an introductory session. But it's just important that you know that there are tax clauses in the ISDA Master. And I guess the other thing is that, as is common in relation to all financial transactions, nobody wants withholding tax to be paid in really any circumstances. And so these provisions within 2D set out what happens. And basically, it's a gross up clause if withholding taxes are imposed on the transactions. But they're designed to apply from the beginning of a relationship rather than being able to flush out what the issues might be on a transaction by transaction basis, particularly if there's a change in law. So again, this is already probably too much detail for these purposes. So it's important that you know that tax provisions are there. And if you want to get into the detail, I would suggest that you read them because Green Tiger Markets does not provide tax advice. Let's be clear. So the next set of provisions is related to the representations. Now, as is common in all financial transactions, whether it be a loan or a derivative or whatever it might be, each party makes certain representations to the other party and vice versa. These are reps that you'll be familiar with. So, for example, that the party has the capacity to enter into the agreements and the transactions that it's entering into, and the transactions has been duly authorized. Now, there's an additional representation that we add specifically for the Philippines market, which I'm going to turn over to Attorney Morales to describe, as it's driven by something he wrote in his opinion to ISDA. So, Attorney Morales, would you mind touching upon this rec and why we need to include it, please?
Oh, yes. It is usual for the parties, especially the Philippine party, to include in the schedule to the ISDA Master Agreement an additional representation in the form that you see in the slide. The intention is to make it clear that the parties are entering into the transaction not for speculation, because the usual issue that arises whether or not the transaction is a gambling sort of a transaction. By putting that additional representation that the parties are entering into the transaction for the purpose of managing its borrowings or hedging, the aim is to avoid a claim that the parties are entering into a gambling transaction. So that's all there is to it.
Thanks very much. And as I said, because of the way that the Green Tiger Markets documentation and the rulebook operates, this representation is in every single transaction between two Philippines counterparties. So it is always made. There's no way of removing it when you trade on Green Tiger Markets. Okay, and then so that's the reps. And then finally, in this list of main provisions when things are going just fine and dandy, is that there are certain miscellaneous agreements which are mainly about providing information from one party to the other. So usually there'd be an obligation to disclose important information like constitutional documents or financial statements, either at the outset of a relationship or on an ongoing basis, so that the counterparties can continue to assess the creditworthiness of the companies with which they're trading. So as I said, these are the main provisions when things are going well. Now, to be honest, when things are going well, parties don't tend to look at the agreement that they signed because everything is working just as it should be. If there's a problem, but both parties are still in good financial standing and everyone, it's just a mistake, then normally things get ironed out by a quick phone call to the other side just to work out what the problem is and try and resolve it promptly and without any real issue. However, when you're in a default situation, that friendly phone call may or may not happen. And it may not be possible for a party that's in default to call up and sort out a problem. And that's when companies really need to look very carefully at the legal provisions that they've agreed and in their contract with their counterparty. And of course, those are found in the ISDA Master, and they're suddenly extremely important for what happens next. So we're going to walk through the events of default, the termination events, which are different to the events of default, and what happens when one of these events leads to the termination of the ISDA Master Agreement, and because it's a single agreement, all the transactions between the two counterparties. So first off, the events of default. So the events of default are provisions that effectively illustrate that the relationship between the two counterparties has potentially broken down. In an event of default scenario, one of the parties, the non-defaulting party, should have the ability to bring down the relationship, bring it all to an end, because these are fault-based events where the defaulting party is at fault. So it's up to the non-defaulting party to determine whether it wants to carry on with the trading relationship or just terminate all the transactions. Now, events of default encompass, and there's a list of them here, the sort of things you can probably imagine, like a failure to pay, where that's been notified to the defaulting party and they still haven't resolved the problem, or an insolvency, bankruptcy, which is where the defaulting party has gone bankrupt and you're just never going to get paid if you're the non-defaulting party. There are some others listed here, but I don't intend to go through them in any real detail today. Typically, it's failures to pay and insolvencies that bring down a relationship most quickly. Some of the other clauses are, of course, extremely important, and they typically are indicative that there's been a deterioration in the creditworthiness on the part of the non-defaulting party. But the most clear-cut events, and certainly in my career so far, where we've had to close out other counterparties, it's been failures to pay or insolvencies that have triggered the event of default. In contrast, the termination events also entitle one or both of the parties to terminate, and they are intended to be non-fault-based provisions. So whereas before we had fault-based provisions in the events of default, the termination events are generally supposed to be non-fault-based provisions. The sorts of provisions that we're dealing with here are things like illegality or sanctions are imposed, for example, which means that it's impossible for one party to make or receive payments to or from the other. So it's not that, there's been a deterioration in creditworthiness, it's that we're just simply not allowed to make these payments any longer. And so we can see from this slide that some of the others are in a similar vein. Force majeure, for example, where it's impossible to make a payment. Now, if you're in the power business, particularly in terms of supply contracts, then force majeure means a particular thing to you in that context, capability of delivery of the fuel, for example. But force majeure in an ISDA context, while the wording of the clause will look quite similar to a force majeure clause in a physical contract, because the performance in a derivative agreement is payment. So it's payment that needs to have an FM attached to it, which means it's much, much rarer for FM to be relevant to ISDA Master, to derivative transactions, because whilst it may be the case that the ship got held up and was unable to deliver on time because of a storm, and that is a genuine FM in a physical agreement, the inability to make a payment, that requires effectively the payment systems to be down, which is obviously much less common than storms on the high seas. So do bear that in mind, that if you're thinking about this if you're a physical commodities lawyer, or you're mostly involved in the physical business, FM is much more rare and much harder to satisfy in a derivatives context than it is in the physical space. So I just want to make that very clear. Okay, so we also have here some other lists. So tax events, that's where there's been a change in the tax law that causes the treatment of the transactions to be different from what was initially in place. And there's one additional event here, credit event upon merger, which is kind of on the cusp of being fault-based. And this is where there's been some kind of corporate activity, an M&A transaction, for example, and the resulting successor entity is much weaker in creditworthiness than the original entity, and that can lead to a termination event as well. So, as I said, one of the key differences between these two is that the events of default allow one party to terminate everything, whereas the termination events potentially allow both parties to terminate everything. Now, that can be changed as well if you have additional termination events, which is basically anything that's agreed between the two parties. So, again, I'm not going to get into the nitty-gritty of that today, but just be aware that you can add things as part of the negotiation too. Okay, so moving on to what happens when one of those events occurs. So this is the thought processes you have to go through if you're pursuing the default termination process. So the first question is, has an event of default or a termination event occurred? And that's not always straightforward. Sometimes it can be in a failure to pay, but you've got to remember that you need to provide notice in a failure to pay before you can trigger it as an event of default. So it's important that if you're in that scenario, you have to think and read the contract carefully to see if there's anything that, if you're the non-defaulting party, if there's anything that you need to do in order to be able to trigger your rights. So that's one element to it. Then once you've determined that you have a right to terminate and you decide to terminate, you designate what's called an early termination date. And on the early termination date, once you've designated it, you then move forward to calculating what the early termination settlement amount should be. And you do that by calculating the market value of all the transactions that are being terminated. So when the parties have wide-ranging trading relationships, let's say it's two banks, for example, that trade a multitude of different products across all their different desks, that can be extremely complicated, calculating that termination amount, and then combining all the different contracts. But when it's relatively vanilla as a product and the pricing is quite clear, then it's normally a bit easier to handle. And we anticipate it being a bit easier to handle when you're trading on Green Tiger markets too. The way that we calculate that termination amount is again, beyond the level of detail that's beyond an introductory session, but effectively it's the replacement cost of the transactions that you're terminating. So having calculated the early termination amount, that is then communicated to the other party. If it's an insolvency situation, then the non-defaulting party will be in the bucket of unsecured creditors, and they basically have to wait to make payment once that insolvency process has been worked through. But if it's a failure to pay scenario and the company is still financially viable, it's just a bad actor, then the non-defaulting party can pursue their claim. Now, for Green Tiger Markets products, we elect for disputes to go to arbitration at the Singapore International Arbitration Center. And I'm going to bring Attorney Morales back in here again to just explain a little why that's important for the Philippines in particular. Attorney Morales, if you'd like to talk about that a little bit.
Yes. It is not advisable to bring a suit before a Philippine court to settle a dispute involving derivative transactions, because Philippine courts have no experience in this esoteric field. That is why the preferable dispute settlement is by arbitration, and the usual the usual tribunal that is resorted to by the parties is the SIAC, because the SIAC has a lot of experience on this matter, and it is located regionally. So it is easily accessible, especially to Philippine parties.
Yeah, thanks very much. And then I guess the one key thing to add as well is that would then be enforceable in the Philippines, right? The award given by the side.
Yes. The Philippines is party to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So an arbitration award is enforceable in the Philippines pursuant to the New York Convention.
Thanks very much. So, and that's why we put that as the forum for disputes in the Green Tiger Markets rulebook. We want all our contracts to be enforceable, and we want people to perform as they should do. Okay, so moving on, this is section 2A3, which is also known as the flawed asset clause. This has been the subject of quite a bit of case law, particularly since the global financial crisis, and I'm not going to go into the detail of that today. But basically, the provision says that each obligation of the party, so that's basically to make payments under the transaction, is subject to the condition precedent that no event of default or potential event of default has occurred and is continuing with respect to the other party, and the condition that no early termination date has been designated. So what does this mean? Well, it means that if my other party is in default, or if I were to give notice or the passing of time would cause them to be in an event of default, then I don't have to perform on my side of the transaction. Okay, so for example, if my counterparty has gone insolvent, but I haven't yet designated an early termination date because I'm still thinking about it, then that I don't have to perform, I don't have to make payment to that insolvent company, even though I haven't terminated the agreement. Similarly, if there's been a failure to pay by my counterparty, but I still need to give notice before I can trigger the event of default, I still don't have to perform my side of the contracts whilst there's still been that failure to pay. So this allows a non-defaulting party to have some breathing space to determine whether or not they want to terminate the ISDA Master Agreement as a whole, which is, of course, helpful. Now, as I mentioned, there's a lot of case law, which I'm not going to get into today, but in practice, it just gives you that time to decide whether or not you want to terminate all the transactions without kind of pushing money out the door if you're the party obliged to make payment under the relevant transactions. So that's an important flawed asset clause. It's a key element of the ISDA Master Agreement. Okay, so when things have all gone wrong, let's look at a quick example of how closeout netting might work. So we talked about payment netting earlier, if you remember. Now we're going to talk about the other type of netting, closeout netting. They're similar, but they're not the same. Okay, so in this example, we have three contracts for differences, where under two of them, party A owes 10 and 5 pesos respectively to party B, and under the last one, party B owes 10 pesos to party A. So what you would do, and that's the market value that they've calculated. They've calculated that the replacement of those transactions would cost these amounts. Okay, so what you look at is, well, what's the net sum? What's the single sum payable by one party to the other? And of course, that's for party A to pay 5 pesos net to party B. That's the closeout amount, which becomes the early termination amount, along with some other elements of costs that need to be included. Okay, very simple. That's how closeout netting works. Now, of course, it can get very complicated depending on how many transactions are in place and some other elements, but that's the basic principle. And that's all we're going to talk about today. Okay, so I mentioned at the outset that we're going to talk about the master agreement itself, the schedule, its key provisions, and then what you might do to negotiate a schedule. We're going to be super quick through this next bit, because again, it can get quite detailed. But just going through some of these elements that are negotiated sometimes between counterparties. So if you decided to negotiate a schedule with your counterparty because you don't just want the form that the Green Tiger Markets rulebook imposes on the relationship, then you would look at things like the termination provisions, where you can adjust what you want to do. And in theory, absolutely everything can be adjusted in the schedule. But the schedule the pre-printed form of the schedule does walk you through a series of key elections that it kind of suggests that you might want to make when you're negotiating it. So part 1 of the schedule deals with termination provisions and any amendments that you might want to make, whether it be threshold for default or grace periods, for example. Then part 2 sets out the tax reps that each party makes to each other, if any. Part 3 is a list of documents that are to be provided at the outset and then on an ongoing basis. I mentioned earlier, constitutional documentation, financial statements, things like that. Part 4 is kind of miscellaneous provisions. So this is boilerplate that you would normally have in any commercial contract. So that would be things like designating who the calculation agent is, for example. And what I would actually mention at this stage is that for Green Tiger Markets transactions, Green Tiger Markets acts as the calculation agent for all of the market participants. So we work out the amounts that are owed between 2 parties under their transactions, and then we'll tell you what those sums are. Then part 5 of the schedule is effectively a blank slate. It's a catch-all section where you'd include any other amendments and provisions that you want to include in your trading relationship with your other counterparty. So in international markets, this is often where we see regulatory amendments being made. But as I said, this is a clean piece of paper that can amend anything and everything that the parties decide in their negotiation. So I've also put a note here about credit support documents too. And so this is where there's 2 elements of this. Either a credit support annex, which is where collateral is posted between parties. And as I said, that's the subject of a future session. But also it might be that you might get credit support from another company within the group, like a group guarantee. So let's say party A is much weaker than party B, and party A is part of a big group where there is an entity, the parent, let's say, that is much more creditworthy than party A. But party A is the trading entity. So it might be that party B asks party A to get a guarantee from its top co in order to feel comfortable in trading just facing party A. And so party A's parent company that's giving that guarantee, they become what's called a credit support provider. And that guarantee is a credit support document. So it might go beyond the parent as well. It could be other entities in the group that might be deemed to be credit support providers too. And that's up to the 2 counterparties to determine what they want to do with that. This is a really brief canter through the schedule. And obviously there's loads more detail that we could go into, but we've only got an hour today. And so this is the introductory element to it. I'm available to answer questions after the session too. We're going to move on now though to confirmations. So while the ISDA Master Agreement with its completed schedule sets out the framework for the relationship between 2 parties as on a kind of overarching level, the confirmation is a document that houses the terms that relate to a particular transaction. And it would normally also incorporate, as I mentioned earlier, one of the definitional booklets published by ISDA. And in Green Tiger Markets case, that's going to be the 2005 commodity definitions. And so if your relationship with the counterparty is already established, you're just then going to look at the individual terms in the confirmation. Now, there are several different types of confirm that you'd routinely see. You often find, if there's no ISDA Master in place, a long form confirmation, which sets out all the terms, all the elections that will be made in a schedule, and all the economic terms of an agreement. Those tend to be, as the name suggests, pretty long. You might have a short form confirmation, which is where there is an ISDA Master in place. And so really, you're just putting in place a short number of terms that relate to the specific transaction. Now, what we do on the Green Tiger Markets marketplace is have what's called a master confirmation agreement. And what this does is pre-bake most of the trade terms into the agreement from the outset. And so the GTM rulebook sets out the standard terms that will appear in every trade confirmation. So that's the terms in the ISDA Master and the ISDA Schedule, which we don't amend a huge amount. And then the standard terms of the contracts. So the tick size, for example, of megawatt hours, or the number of hours that we refer to depending on the product. So, for example, we have the product lose on round the clock for a calendar month. And what that means is that the price of the lose on electricity over the course of an entire month, as it's published in every 5-minute window over the course of the entire period on a 24-hour basis. Okay, that's pre-baked into the agreement because it's part of the GTM rulebook. Okay, so what that means is that when you get a transaction executed, the trade confirmation itself looks very short and neat. It has the counterparty with which you've traded, because that's anonymous until a transaction is entered into. Of course, as we've probably mentioned to you a number of times before, you're only ever going to be matched with a counterparty that has already been pre-approved by you for trading. It also set out the price that was agreed and bilaterally negotiated, either via the central limit order book or via the voice broker service. And it will set out the quantity of megawatt hours that is the subject of that contract. And then the products. So that's the location and the period of time over which the reference will look. So as I said, like round the clock for January is a particular product. So that's how, those of you who've either been part of a simulation or have actually traded on the marketplace will have seen that the trade confirmation that comes through on email looks very short. And the reason that we're able to do that with such standardized elements is because a lot of everything else is pre-baked via the GTM rulebook and the ISDA Master Agreement as the kind of underlying framework for all transactions on the Green Tiger marketplace. Okay, so that, as I said, that's a very quick canter through the key elements of the trade confirm with a specific focus on how that operates on the Green Tiger marketplace. There are other bells and whistles that you would put into it if you were trading on an OTC bilateral basis, where maybe you're doing a more complicated product, but that again is beyond the scope of our session today. We have got one bit more time at the end, though, to talk about a couple of elements of Philippines regulatory law that have come up in our meetings with market participants over the last couple of years. And I'm going to hand over again to Attorney Morales to go through those now. So let's start, if it's okay, Attorney Morales, with the SRC definitions of securities, which has come up a fair few times.
Yes, the definition of securities in the Securities Regulation Code is different from the definition of the term in the Revised Securities Act. In the Revised Securities Act, securities are defined by examples. They just say securities include 1, 2, 3, 4. Okay, but in the SRC, there are two sentences. The first sentence contains the operative definition of the term securities, and the first sentence is actually in front of you, and this is set out in the slide. It says that securities are shares, participation, or interest in a corporation or in a commercial enterprise, and is evidenced by a certificate, contract, instrument, whether written or electronic. And then the second sentence gives examples of what might be securities, but not all the examples there would constitute security unless they satisfy the operative definition of the term securities. And that is why participants in the GTM market that avail themselves of the facilities of GTM do not become shareholders of GTM or acquire any interest therein. And hence, the GTM contract is not classifiable as securities under the Securities Regulation Code.
Yeah, thanks for clearing that up. I mean, that's super clear to me. Obviously, if you trade on GTM, you don't get an interest in the company. You're just entering into a contract for difference for the price of the commodity. So that's something that's been discussed quite a bit in our meetings, and I thought it'd be helpful to reference here today in this session. And the second element to this Philippines regulatory landscape is commodities futures contract, which again there's been some confusion over whether this captures the contracts on GTM, and I know that we've discussed this before at length Attorney Morales, and that is not the case. These contracts don't fall under the scope of futures contracts. Would you like to talk about that a little bit?
Yes, the quoted definition in the slide is the definition that was accepted by the Supreme Court of the Philippines in the case of ONAPAL Philippines Commodities versus Court of Appeals. Based on the definition, the GTM contract would not fall within the scope of commodity futures contract because there is no delivery of electricity contemplated under the contract. And even assuming that, for the sake of discussion, that GTM contracts are classifiable as commodity futures contract, it is not covered by Section 11 of the SRC. Because, in Section 11, there is a statement there that persons are prohibited from entering into commodity futures contract until the SEC shall have promulgated the rules of trading governing commodities futures contract. But Section 11 does not envisage bilateral contracts. According to the SEC in its publication setting for the history of the SRC, Section 11 is meant to govern publicly traded commodity futures contract. Section 11 does not prohibit parties to negotiate and conclude bilaterally commodity futures contract. And actually, if you examine the Personal Property Security Act that was enacted in 2018, it is clear that commodity futures contract can be an asset that can be used as collateral in credit transactions. So it can be argued actually that Section 11 has been impliedly repealed already by the Personal Property Security Act.
That's interesting. I hadn't been aware of that last element. But I think the key thing is because all the transactions on the GTM marketplace are bilaterally negotiated because of the way that the central limit order book works, or the voice service that we provide. They are not futures contracts under the definition by the Supreme Court in that case, in the ONAPAL case. So thanks very much, Attorney Morales. I thought, because this is the introduction to the ISDA elements, but these are two questions that have come up quite a bit, and so we felt like it was important to include them in this first Learning Academy session. So we've covered a lot of ground today, and we've crept in at 4 o'clock. Thank you very much for joining us. I have a bit of time to answer any questions you might have. If you do have them, please either use the chat function, as I've said before, or take yourself off mute and ask. Don't be shy. It's absolutely fine. There are no bad questions. This is an introductory session, and so any question is absolutely fine to ask. None forthcoming right now, but if you would like to ask any questions outside of the large group of people that we have here today, then that's absolutely fine too. Please feel free to get in touch with me directly. You have my email address as part of, we'll send my email address out after the session if you haven't got it already, and maybe we can have a chat separately to this session. Thanks again to Attorney Morales for joining us today. It really has been extremely helpful to have you guiding us in terms of our launch of the platform for the Philippines, but also having you here today to talk to the market participants about how these rules apply to them specifically in the jurisdiction has been extremely helpful. So thank you very much for joining us. And thank you everyone for joining us too, and joining us here on this first Learning Academy session. We hope to see you for the future ones, and you'll receive emails about them in due course. If you had this email forwarded to you by a colleague and you would like to join the list for future sessions, please get in touch with us at, I think it's info@greentigermarkets.com. Alexis, you're on, is that correct?
Yes, that's correct.
Right, so that's info@greentigermarkets.com if you'd like to be added to the mailing list going forward. Otherwise, have a fantastic day, and we look forward to seeing you again in the future. Thank you very much.